By any standard and by every measure, this is an amazing time in the United States Supreme Court. I cannot think of any time in American history where there are so many terms in a row with blockbuster cases that affect all of us and often change the law in significant ways. I thought that I would take a few minutes this afternoon to talk about the Supreme Court's immediate past, its current term, its present, and a little bit about the future to come. In terms of the immediate past, last year the Supreme Court decided 66 cases after briefing and oral argument. It's almost identical to the 68 cases that they decided the year before. The year before that it was 73 cases. The year before that it was 65, which was the smallest number in any year in my lifetime. To put that in some context, for much of the 20th century, the Supreme Court was deciding over 200 cases a year. As recently as the 1980s, the court was averaging over 160 cases a year. To go from 160 cases a term to last term's 66 decisions is truly remarkable. Last year, for the first time ever, the justice most often in the majority was Justice Stephen Breyer. He was the majority in 92% of all of the cases. Last year, for the first time ever, the justice most often in the majority in the 5-4 decisions was Justice Stephen Breyer. He was the majority in 75% of the 5-4 rulings. This reflects something very important about last term, which is officially known as October term 2014. The 4 liberal justices, Ginsburg, Breyer, Sotomayor, and Kagan, were the majority in most of the major rulings of the term. They were the majority in most of the criminal law and criminal procedure cases, all the First Amendment cases, all the civil rights cases, all the separation of powers cases. You might have read an article by Adam Liptak in the New York Times that described last term as the most liberal since the end of the Warren Court in 1969. Why? And what's it likely to mean for the future? In large part, I think it's explained by the voting behavior of Justice Anthony Kennedy. Last year was the 10th term with John Roberts as Chief Justice. If you look at the prior 9 years, and you focus on the ideologically divided 5-4 decisions, where on the one side you had Roberts, Scalia, Thomas, and Alito, the other most recently, Ginsburg, Breyer, and Kagan. Justice Kennedy voted with the conservatives 70% of the time, and with the liberals 30% of the time. Last year was different, though. Last term there were 14 ideologically divided 5-4 cases. Justice Kennedy was the liberals in 9, with the conservatives in only 5. But that doesn't tell the whole story. Another key part of what explains last term was the cohesiveness of the 4 liberal justices. There were 19 5-4 decisions last year. They voted together in 16 of 19. What does this mean for the future? You probably read the same articles I did, speculating on whether this shows the Roberts Court is turning left and becoming more liberal. I would strongly caution against such a conclusion. I'd caution against ever drawing conclusions from one term of the Supreme Court. Had we focused on the term before last, October term 2013, the dominant story was the unanimity of the justices. In 66% of all the cases, the court was unanimous. Last year, only 34% of the decisions were unanimous. As I'll talk about in a moment, this term the court has before it cases about affirmative action, the First Amendment rights of non-union members, election districting, abortion. These are all areas where historically Justice Kennedy sides with the conservatives much more than with the liberals. So to pick an analogy that seems particularly appropriate this year, if last term for liberals was the return of the Jedi, this term, well, it could be for conservatives, the Empire Strikes Back. I think that last term was distinguished by 2 cases that were by far the most important. One was constitutional, the other was statutory, Yet I'd suggest they share some things in common. The constitutional case was Oberthal versus Hodges, came down on Friday, June 26th. There, the Supreme Court declared unconstitutional laws in Kentucky, Michigan, Ohio, and Tennessee that prohibited same-sex marriage. Justice Kennedy wrote for the court, joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. Each of the 4 dissenters wrote a separate opinion. The other blockbuster case of the term was the day before, King versus Burwell. There, the Supreme Court held that all who qualify economically are entitled to tax credits from the federal government, whether it is from a plan established by a state government or exchange created by the federal government. Just here in Florida, it means that 1.5 million people will continue to receive tax credits and be able to afford insurance that otherwise they wouldn't have. So I said that I think these cases share some things in common. I think they're important from a jurisprudential perspective. Since coming on the Supreme Court in 1986, Justice Antonin Scalia has repeatedly said that we should follow an originalist approach to interpreting the Constitution. That the meaning of a constitutional provision is fixed at the time it's adopted, it changes only by amendment. Oberthal versus Hodges is an emphatic rejection of originalism. Justice Kennedy's opinion embraces the idea of a living Constitution. Since coming on the court in 1986, Justice Scalia has repeatedly taken the view that a statute should be interpreted just based on its plain language. He rejects looking to legislative purpose, and especially rejects looking to legislative history. Chief Justice Roberts' opinion in King versus Burwell is an emphatic rejection of plain meaning statutory interpretation. Chief Justice Roberts' opinion is all about how to interpret the statute to effectuate underlying congressional purposes. But perhaps most of all, what these cases reflect is how much the Supreme Court's decisions affect all of us. I always encourage my students to think of cases not just in terms of their doctrinal significance, but with regard to their effects on people's lives. Because of Oberthal versus Hodges, same-sex couples now can marry in all 50 states and all territories of the United States. Because of King versus Burwell, between 6.5 and 10 million people will continue to have health insurance that otherwise they would do without. Think of the lives saved, the suffering prevented. These cases really do show us how much the Supreme Court's decisions affect all of us, often the most important, the most intimate aspects of our lives.